Good morning, everyone. My name is Lakesh Khajani, founder and CEO of Biotech Systems. Beyond my personal life, I'm a cloud volunteer with ACISA, the Arts and Culture Initiative of South Asia, and I'm delighted to be your moderator for today's session. As many of you know, ACISA is the heartbeat of South Asian culture in our region. We are the team behind Vibrant Brampton, which celebrated its landmark anniversary last year as Canada's largest South Asian summer festival. Our commitment to the community spans all across generations, from the Vasa exhibition for local visual artists and Rooted Fest for our youth, to our dedicated programming for seniors, whether it's yoga, digital literacy, or music workshop. We are committed to keeping our seniors active, connected, and informed. Before I talk about today's webinar, I would like to mention the visionaries behind ATISA: Ruki Bajaj, Arpan Banerjee, Sandeep Pagakar, and Apana Raghunath, our board of directors. Today, we focus on a vital topic many of you have asked for: state planning and preserving your legacy. Creating a legacy is an important part of being remembered. It is what makes you unique and allow you to share resources that benefit generations to follow. This session is held in proud partnership with the Indian Heritage Society Brampton and is made possible through the generous support of Canada's New Horizons Senior Grant and Ontario Seniors Community Grant Program. Special thanks to Sajit Nair, Associate Wealth Advisor, SV Wealth Raymond James Limited, who has been instrumental in getting the webinar together for us. To lead us today, we are joined by Riaan Botha, AVP of State and Trust Solution at Solus Trust. Riaan brings over 2 decades of expertise in legal, fiduciary, and tax sectors across 13 international jurisdictions. Go ahead, Riaan, please. Thank you. Okay. He holds a Bachelor of Commerce in LLB, a postgraduate diploma in tax, and is a full member of Society of Trust and Estate Practitioner. It's called STEP. Riaan, we are eager to learn about the significance of updated wills and power of attorney. I'll turn the floor over to you. Thank you.
Lokesh, I don't know if you can hear me, but I could not hear anything you just said.
Can you hear me? Hear you. Yeah, I can hear you.
Can you hear me? Yeah, I couldn't hear.
We can hear you.
Yeah,
if anybody else that's on can just confirm. Okay, perfect.
Yeah.
So can I start? I couldn't hear anything you just said. Good morning, everyone. Give me 1 second. I'm going to share my screen, and then I can start the presentation.
Riaan, are you able to hear us?
Just give me a thumbs up if you can see my screen. Okay. Give me 1 second.
I think Riaan is not able to hear.
Yeah, so good morning, everyone, and welcome to this webinar on estate planning and the joys of being an executor. It's not a fun discussion to have, but it's one of those discussions. If you do not properly plan, unfortunately, you do not have anything. So on the agenda today, what we'll look at is estate planning in the Canadian landscape. Then we'll go into the estate plan itself. What does it consist of, and what sort of pitfalls you can potentially look out for. Then we'll go into the estate administration and what that entails, some of the specific considerations that you need to look at, and then I can go a bit into detail into the services that Solus Trust provide to see if we can be of assistance to anybody. So compared to the global numbers, the Canadians are doing fairly well in ensuring they have a will in place. We just need to ensure that the younger generation are educated on the importance of estate planning, financial planning, and the importance of having a will in place. As you can see, the Canadian population is an aging population. And if we don't promote the effective transfer of wealth by acting as educators and influencers, this wealth will not effectively transfer to next generations. So, what is estate planning? Estate planning is the process of anticipating and arranging for the management and disposal of a person's estate during the person's life in preparation for a person's future incapacity or death. So it's not just looking at drafting a will, but it's looking at the bigger picture as well. Some of the main estate objectives of an estate plan should be to minimize taxes at death, to maximize the inheritance value, ensure that the person's last wishes are met, minimizing legal expenses, and simplifying the estate settlement process for those people that are left behind. Make sure also that you address your digital assets as part of this plan. So a few things to consider when you're constructing your will or your estate plan. I'm just going to name a few. There are a number of accounts where you have a named beneficiary. This is fantastic as the asset can go directly to your beneficiaries and do not need to get probated. You must be aware that the tax attributes back to the estate, which if not planned properly can leave an estate insolvent or detract from the estate beneficiary's unintention. Assets that are jointly owned, such as a home with a joint tenant with right to survivorship, transfer to the survivor automatically. So if you are joint with right to survivorship on an asset, just make sure how that is going to transfer as part of your bigger plan. Joint tenants in common, a different form of ownership, is where two parties, for instance, have 50-50 interest in a property, and it's like owning company shares. So upon your passing, your 50% will flow through the will or through the deceased estate to that person's designated beneficiaries. When we pass on, there is a deemed disposition of your assets, and so death is usually the biggest tax event most of us will ever face. That's why it's important not to leave things to chance, but to plan properly on how to potentially minimize that. One of the other factors is if you have business interest. If you, for instance, have a operating company with partners, do you have a plan for if one of the principals passes on? Do you have a buy and sell in place? What often happens is people are so busy in the day-to-day administration of their corporations that they do not plan effectively for the transition, either at sale or at death, or sometimes even at incapacity. So that's why it's very important to look at that. So why does estate planning matter? It really is the final document that sets out your wishes. It allows you the option to protect loved ones and prevent family disputes, and it preserves your legacy. It is really the final document that sets out how your estate should potentially be protected for future generations, such as kids to be held in trust, etc. If you, for instance, sit in the situation where certain assets flow through to children that is not capable of managing financial affairs. I've been in this industry now for 25 years. I've seen where quickly the estate can dissipate and nothing is left for the beneficiaries. So some of the core elements of an estate plan is wills and trusts. In the Canadian landscape, majority of people would look at wills. You would often hear people in the US set up trusts. The legislation in Canada versus the US is completely different, both from a tax as well as an administrative perspective. So in Canada, a trust is taxed at the highest marginal tax rate, but is still a good vehicle to potentially utilize in order to effectively transfer wealth to next generations and potentially lessen tax implications on the people involved. Second one is beneficiary designations, as I mentioned earlier. It is if you've got registered accounts such as RSPs, TFSAs, or RIFs, or life insurance policies, then you can name beneficiaries directly on those accounts, and it will transfer outside of the estate to those beneficiaries. Fourth one is asset protection. So again, as I said, if you, for instance, structure your estate through the utilization of trust, it can protect the estate from creditors or other unintended implications. And then, as I said, the cherry on top of the cake with this is to look at tax minimization and seeing how we can potentially utilize estate freezes or other trust structures to potentially minimize the taxes during your lifetime as well as then at your passing. So some of the key considerations in estate planning is residency, tax and assets. If you are just a Canadian resident, then we need to see what the implications are at death as well as during your lifetime. If there's a cross-border component, both from a citizenship, residency, and potential asset structure perspective, we need to ascertain what's going to be the best way to proceed in building this estate plan that there's no unintended consequences. Next one is family dynamics. It is probably the biggest portion of estate planning is looking at family dynamics. What people often do is they appoint family or friends as executors, and potentially a case where there might just be one beneficiary that out of 3 siblings that's acting as the executor. And if something goes wrong, that's where the family dynamics comes in, and it really tests the family strength in making sure that everything is done correctly. If you have kids with special needs or other family beneficiaries with special needs, we need to take that into consideration. And some of the biggest things nowadays is looking at blended families to see how to effectively transfer wealth to 2 different potential families. So if mom has her kids and dad has his kids, we want to make sure that transfer to, if mom or dad should pass away first, that it goes effectively to the survivor, and from there on effectively to the individual families. Because what often happens, it transfers across to the one spouse. That spouse has the testamentary freedom to decide how to then distribute the assets upon his or her passing. And if it's not in line with what the main intention was while both were still alive, it can really end up in a situation where something is then transferred across to only one side of the family and the other family is completely left in destitute. Charitable giving, again, a good opportunity through estate planning is to potentially look at providing for charitable giving. As I mentioned earlier, when you pass on, there is a deemed disposition of assets and taxes are payable on that. Any gifts to charitable organization allows for a tax credit that could potentially lessen the taxes payable on the estate. If we look at business interest, as said, we are there to make sure that everything is done accordingly. You need to focus on building your business. As a team of financial professionals, we are there to assist in making sure that the estate planning portion of that is properly taken care of. If there's any support obligations such as alimony or child support or other dependents, then you need to make sure that that's properly catered for, either in the estate plan itself or through, for instance, life insurance that can then be paid out to those beneficiaries to effectively cater for that. So what does it mean to create an effective will? So what are the legal requirements in Canada? Your will must be in writing, signed by you at the end, and witnessed by 2 people who do not benefit from the will. Requirements can vary slightly by provinces, particularly in Quebec, where civil law applies. Some of the key components: an effective will appoints executors, designates guardians for minor children, outlines specific bequest of personal items, does not need to necessarily be in the will, it can also be in a letter of wishes, personal items, and details the distribution of how the remainder of your estate would then be divided between beneficiaries and could also potentially include funeral and burial wishes. Some of the common pitfalls is avoid issues by updating your will only after, not updating your will only after major life events such as marriage, divorce, birth, big change in assets. And then, as I mentioned earlier, we are living in a digital age, so you need to make sure that you've got sufficient clauses in there that your executor has the authority to deal with digital assets. So what happens if you die without a will? So there's default distribution in Ontario that determines how your estate should be divided, and I'll go through that a bit later. It's a process then through a court application of who should then be appointed as the administrator or executor or estate trustee, as it's known in Ontario. And what often happens, there are family disputes and delays. As I mentioned, I've been in this industry long enough to see the good, the bad, and the ugly. And it is really a situation that if you do not have this basic document in place, you potentially don't have the option to dictate or provide guidance on how it should be handled. And then again, looking at guardianship uncertainty that is then addressed effectively through the will. So in essence, it's your legacy, your way. Estate planning is ultimately an act of love, a gift of clarity, protection, and security that you leave for the people and the causes you care about most. It protects your family, it preserves your wealth, and defines your legacy. This is the only document that you have at your disposal to effectively address all these needs. So let's move into the executor itself. It is one of those jobs that most people don't apply for it. You are nominated to act in the capacity as executor by the testator, the person that drafts the will, and then you have the option to either accept the appointment or renounce the appointment before you start acting. So some of the factors that we need to look at when you need to decide who to appoint as the executor. The first one is time. I'll go into a bit more detail on the next slide on that. Second one is age. If the person that is appointed as your executor is of the same or older age than you, and you don't make proper provision for a backup, should that person pass away before you, then there might be a potential gap that will then have to be addressed. So make sure the person that you appoint or the backup, that person is effectively backed up again by somebody else if something should happen to him, or by a professional such as a trust company that potentially never dies. Third one is knowledge. This is an ever-changing industry over the last 10 to 15 years. Globally, there's been significant changes pertaining to tax as well as administration. So the person acting in this capacity should have the knowledge to effectively do what they need to do. If they don't, then number 6, personal liability comes in, and the person acting in this capacity as the executor is held personally liable for all aspects of the estate. Fourth one is executor location. We live in a country that a lot of people have family outside of Canada, and what often happens is they appoint a person outside of Canada to act in the capacity as executor. That could potentially attract additional taxes as well as other administrative constraints. So make sure that the person that you appoint in the capacity as executor, that person is close to you where you reside, because there's a bunch of stuff that needs to be done in person. And preferably, if that's not possible, at least that the person is within province to effectively handle that. If there's any assets outside of Canada, then what we normally do is we assess where those assets are, what the laws of that specific jurisdiction states pertaining to succession, and then see how to best handle that. It might be beneficial to consider setting up a Canadian will and, for instance, a will in the other jurisdiction where the assets are held. So on this slide, you'll see that it takes on average about 570 hours of effort over a period of 16 to 18 months to settle an estate. And you'll see at the bottom right, I refer to the estate value does not always equal estate complexity. People often think that appointing a professional in the capacity as executor is only for complex estates. If there is complex family dynamics, I would always advise to potentially then get an independent in place to handle the executor services. That would remove that burden and avoid potential conflict within the beneficiaries, and the estate is handled a lot more efficiently as part of that process. This is just a high-level overview of some of the duties of the executor. We will go into a bit more detail on some of this in some of the next slides. So if we go into the estate administration process, again, as I said, this is a lengthy process that I can promise you does not take less than 12 months, even in the simplest estates where it is a principal residence, bank account, personal items, and a bit of investments. It is a lengthy process in order for the executor to obtain probate, and from there on then dealing with financial institutions and other institutions on getting things done. So what is the first steps when acting as the executor and the person has now passed on and the person needs to start acting? The first one is to find and review the will, collect and review all important documents. It is the executor's responsibility to make funeral arrangements if that is not given to somebody else to do. Then make contact with all the beneficiaries. You need to freeze, cancel, and or redirect all financial and service accounts, redirect mail, and then assess the immediate needs of dependents, pets, and assets. Nowadays, we even have pet trusts that we've all probably seen over the last couple of years, where people leave large sums of money to people that is then going to be looking after pets. So this is normally called a pet trust, where the assets are then held in that trust and given to the trustees for them to effectively take care of the pets. So, and then what's next? So dealing with all the assets, liabilities, and ongoing transactions. There's accounting involved, tax filings and clearance certificates, and then dealing with the beneficiaries, communication and distribution of assets. Again, referring to the last point, if there are already strained family dynamics, dealing with beneficiaries in a case like that could put even more strain on the family. And you have probably all heard of somebody where there is potentially litigation going on where somebody has passed on. And for me, that's the biggest part of my job, is making sure I educate people effectively to avoid litigation in the future. So let's go into the steps. So step one, as I said, is locate and review the will. So the first task for an executor is to locate the will. Hopefully the executor was told by the deceased about where the will is kept, whether it is in a safety deposit box or a drawer in the room. The problem we have nowadays with potentially leaving a will in a safety deposit box is, in order for the executor to access the safety deposit box, they need probate. In order to get probate, they need the will. So it's a catch-22. If the testator had introduced the executor to their lawyer or their advisor, the executor may be able to locate the will through the advisor or the lawyer. If the will cannot be located, the deceased is presumed to die without a will, and intestacy rules will apply. This is why it's important for testator and executor to work closely together. I've had numerous situations where this has happened, where I know the person had a will, but when they passed on, we could not find the will. That's why we as a company do provide the services of safekeeping a will. So if you die without a will, the heirs are subject to provincially regulated schedules. So in Ontario, if you've got a situation where there's a spouse and children, the spouse gets the first $350,000. And then the remainder is then divided 2/3 to the children and 1/3 to the spouse. So an example of that is where a person dies interstate in respect of property and leaves a spouse and 2 children. The spouse and the children are each entitled to 1/2 of the residue of the property after payment of the $350,000 to the spouse. Therefore, if the net value of the estate was $3 million, the spouse would receive the first 350. The remaining 2.65 million would be divided with 1.325 divided equally amongst the children and 1.325 more going to the spouse. So again, if that was not the intended wishes, that's why it's important to have a will in place to specify how that should happen. Common law spouses are not included. So if you are part of a common law spouse setup and you pass away and you don't have a will, you are not considered a spouse and you will not inherit the first 350 as well as, in this case, the additional 1.325 million. It will go to the kids outright in this scenario. So again, make sure that if you're in a common law setup that there is a will in place. Next step would then be to make funeral arrangements. So again, once the will is located, it may contain the testator's wishes for funeral arrangements, or if the testator had prepared for funeral arrangements, sometimes funeral arrangements may be made by family members, as I mentioned earlier, or if not, then it is the responsibility of the executor to effectively handle it. We do it often as well as a trust company where somebody has no other family, then we take over the full process of then arranging for the funeral. This is probably my best advice that I can give is solicit professional counsel. We live in an environment where if we've got enough professional counsel around us to be able to assist, do not place yourself into a position where you try and do something and potentially expose yourself to liabilities and other issues. So executor support is something that we provide, as well as various other institutions, as well as lawyers will be able to provide executor support to effectively put you on the right track to avoid doing any incurring any liabilities. Next step is notifying the beneficiaries and others. So again, the executor needs to notify the beneficiaries of what the will said, what they would be inheriting, and then constantly keep them updated throughout the process of where they are pertaining to the estate administration process. So dealing with the beneficiaries, even if the executor is completing their duties in a timely and skilled manner, beneficiaries may not perceive this as if communication is lacking. So remember, because this is something that takes very long, there's going to be stages where the executor is going to be waiting for information. There's going to be stages where we've submitted for the probate application and it's now awaiting the approval of the court. If the beneficiaries are not fully aware of what's going on, they may start questioning what's happening. So it's very important to set expectations from the outset. The residual beneficiaries are entitled to accounting of the assets, expenses, liabilities, income, losses, distribution, and then if the executor is being paid or compensated, exactly what that entails. Then, so Now we go into securing the estate assets and then applying for probate. So the executor would be responsible for locating all assets and ensuring the assets are secured until distribution to the beneficiaries. They will prepare a complete inventory of the deceased assets and liabilities using the value at date of death, and this is then also included in the estate information return that is submitted as part of the probate application to determine what the probate fees are that need to be paid. One source of information may be to look at prior year's tax returns to identify assets and liabilities from the income and expenses reported on the tax return and ensure any carry forward tax balances are used. Generally, executor will use death certificate to manage the deceased's assets. Obtain multiple copies from the funeral home when that time comes, because you're going to need that. And then securing may involve changing locks on the real estate or switching to more conservative investments. Then the next step would be submitting the will for probate. This is a process that will then be handled by the estate lawyer. So how is the fee calculated? So the fee for probate is based on the value of the deceased estate. The executor would add up the assets of the deceased estate, and the fee is charged as a percentage of those assets. So some of the assets included in that value would be stocks, bonds, mutual funds, real estate, jewelry, automobiles, and then if any RSPs, RIFs, life insurance is payable to the estate, or some of the excluded assets could be mortgages on real estate, RSPs, insurance, etc., where you've got a designated beneficiary, and then most importantly, any jointly held assets. Joint with right to survivorship assets are not included because, as I mentioned earlier, that automatically then transfers across to the joint owner. So this is an example of how probate fees are calculated. So let's say the value of the estate is $2 million. The probate fee would then be 1.5% on $1.95 million, which equates to then $29,250. The reason only on the 1.5, because as you can see at the top, the first $50,000 is exempt. From there on, it's 1.5% probate in Ontario. So remember, this is only probate fees. This is not income taxes that will then also have to be paid at some stage. Probate is only required if there are probatable assets, such as real estate and non-registered bank accounts. If one asset requires probate, then all assets in the estate or in the will may be subject to probate. In Ontario, we have the ability to make a primary and secondary will. Primary will dealing with the personal assets that need to go through the estate, and secondary will, such as shares held in companies that do not need to go through probate. So if you are in a structure where you've got corporate assets or potentially other assets that is exempt from probate, then I would always advise to have a primary and secondary will to minimize not just probate taxes, but also the process of going through probate. Probate in Toronto currently varies from 7 to 14 months to get probate. And remember, a lot of the assets then sit still. There's nothing that can be done with those assets until probate has been received. Next step would be advertising for creditors. And this is a step that a lot of amateur executors miss and can potentially then in the future come back and be a problem for them. So as part of notifying beneficiaries and others, executors are generally advised to advertise for creditors in the local newspaper. Any request from creditors should go to the executor directly, and it ensures that creditors don't go after the executor post the asset distribution. Because acting as the executor, we don't always know what the outstanding creditors are, and this is a way of making sure that everybody is then kept in the loop. Next step would be to pay the debts and then complete the final tax return. So once all outstanding debts and taxes have been paid, the final tax return would be filed and a clearance certificate would be obtained from the CRA to protect the executor from personal liability before distributing the assets to the beneficiaries. What we normally do is we will do an interim distribution and then have a holdback to take care of any future taxes. Once we receive the clearance certificate from the CRA, then the final distribution will take place to the beneficiaries. Next step would be to distribute the inheritance to the beneficiaries. And as I said, when distributing assets, any beneficiaries receive cash or specific bequests are paid first. These are called legatees. This is followed by transferring assets to any testamentary trust created under the will. So if you, for instance, stipulate that an inheritance of a beneficiary should be held in trust until that person attains a certain age, that would then be transferred to that. And then finally, the residue of the estate is paid out. Generally, executors will get the beneficiaries to sign off in writing that they have received what they are entitled to and they agree with the accounts. This also protects the executor from any future comebacks from the beneficiaries. So we can provide a checklist to everybody as part of this webinar to make sure that the executors that's acting in that capacity know exactly what they need to do and have a full steps to follow. Next one is estate accounting. Remember that if you're acting as the executor, you're acting in a fiduciary capacity to the beneficiaries, and you need to account for the following. So capital, so that's assets and liabilities on the one side, and then income and expenses or transactions on the other side. If you are unable to effectively account for any part of this, again, you expose yourself to potential issues that could be a problem for the executor. So estate accounting is initially you do a date of death snapshot and then draft a assets and liability report that will show you exactly what the assets are, and then record all transactions. If you have paid as a beneficiary and the executor potentially the funeral expenses, then that should be recorded and can be claimed back by that person as part of this. But never commingle estate transactions with personal transactions, because that could easily then turn into a situation where either the CRA, creditors, or the beneficiaries can potentially find an issue with that, and you can be held personally liable. The next important thing is to have an estate bank account. As I said, the day a person passes on, the executor is then appointed, and then the executor will open an estate bank account that is then utilized in order to receive all income and pay all expenses on behalf of the estate. It, as I mentioned earlier, it avoids commingling of assets, it maintains record of all transactions, avoids mismanagement of specific accounts and investments, and most definitely it protects the executor from any future comebacks. So what can you do to effectively assist your executor from executor liability? So as you can see, there's quite a few potential liabilities that the executor might be exposed to. So executors might, for instance, be personally liable for loss in value of the estate. A good example of that is where an executor, a couple of years ago in a case, the beneficiaries of an estate was a niece, nephew, and a charity. One of the assets in the estate was a cottage. The executor needed to sell the cottage to then be able to distribute the proceeds equally between the three beneficiaries. In this case, the executor decided to give the niece and nephew access to the cottage for the last time before they put it on the market to be sold. About 11 months later, they put the cottage on the market, and unfortunately, it was that time where property values in cottage country went down significantly. The value of the cottage went down so much that the charity sued the executor for the reduction in value and was successful in their claim to then get the additional value out of the executor. So again, as I said, preparing your executor is the best thing that you can do. So keep estate documents updated. As and when things change during your life, make sure that those documents are accordingly updated. Understand the structure of your own assets. If you're going to struggle understanding that, then I can promise you your executor is going to struggle as well. Consider your choice of executor. Those days of it being seen as an honor, acting as an executor is gone. It is a job that needs to be done. And if you are able to appoint a professional, yes, there is a cost involved in appointing a professional. I am a firm believer that you will benefit your beneficiaries through that, because then you've got independence as well as a person that knows what they're doing to be able to then effectively transfer the estate and handle the estate administration. So keep an updated estate information, integrated will memo. So integrated will memo is basically a letter of wishes that you can stipulate what should happen to specific assets, personal assets, etc. That makes it easier on the executor as well to then effectively transfer those personal items to the beneficiaries. Because normally what happens, it is not the big money that becomes the point of contention in estates. It is the small personal items that wasn't discussed as part of the estate transition, and that then becomes the problem. The painting, I've done various articles on the material or even immaterial items as part of the estate and how to effectively transfer that. So how will obligations be met upon death? So remember, there's contractual and family support, and then create a business succession plan. If you are part of a business, make sure there's a effective estate plan to address that. If we go into how Solus Trust, as part of Raymond James, can assist in this. So these are the services that we provide as an organization. We can be named directly in terms of the will as the executor to then handle the full estate administration process upon your passing. Or let's say you are appointed as the executor, and you are now acting as the executor, but you feel you don't have the time, the knowledge, or the ability to handle this. You potentially then have the option through our executor support service to appoint us as agent, and we then handle the full administration of the estate. So again, just keep that in mind as part of who you appoint and if you are appointed as well. We can also act as trustee. So should a beneficiary, or should an executor, for instance, establish a testamentary trust, again, we can then act as the trustee for that. And then, again, if you are currently acting as trustee on an existing trust and you feel that this is too much or you don't have the knowledge, you can appoint us as agent. We can also act as attorney for property. So when you become mentally incapable, a attorney for property steps into your shoes to then manage your financial affairs. Your attorney for personal care makes decisions pertaining to healthcare, lodging, food, etc. The attorney for property needs to be a Canadian resident, preferably, because again, as acting in the capacity as an executor, if the person is outside of Canada, then there are potential other tax and other implications. So make sure that your documentation is up to date with the designated appointees being Canadian residents. Legacy planning is basically what I specialize in, to assist clients in structuring their estates to be as tax efficient as possible and maximizing wealth transfer. And then we do offer the services of a will bank, as I mentioned earlier. This is one of those documents that if you do not have the original will, you potentially don't have anything. Simplify is a bill payment service that we provide. So if you are either a busy individual and cannot get to those monthly bill payments or expense payments, then we can be appointed, or we can open up a Simplify account for you and then facilitate that on your behalf. And then should there be a charitable need as part of your estate plan, we can see how we can potentially incorporate a charitable giving fund or a donor advised fund as part of your structure to then effectively transfer wealth across to those charities. In essence, what that allows you is, if you've got multiple charities that you would want to benefit out of your estate plan, you can set up a charitable giving fund or instruct your executor to set up a charitable giving fund. Then incorporate a letter of wishes as part of that, where you give instruction to the fund on how to distribute the grants to the various charities in that year and for future years. A good example is if you want to give a large sum of money to a smaller charity, what often happens is those charities don't know how to effectively manage this. A charitable giving fund will give the investment manager the opportunity to sit with the individual acting as the executor in this case, or the person taking over the management of the charitable giving fund, to then effectively manage the investment and then on an annual basis distribute smaller amounts to those charities. How I operate is I work with the advisors within Raymond James as well as externally to effectively handle the total wealth solution. So in this case, Sabu, Sujit, and the SV Wealth team will look after the investment management, financial planning, the insurance solutions. And then as part of our bigger team, we then have access to further tax solutions advice. I look after the estate and trust as well as the charitable giving side of things. So what we want to do together with the SV Wealth team is to be able to provide you a full holistic opportunity for wealth management. That could then, and the SV Wealth Management team can then also assist you in putting a effective estate plan in place. There's a few links that you can have a look at if you want to look at more information about Solus Trust. And that is my presentation.
I will open this forum for question. So if anyone has any question, please go off mute and go ahead and ask the question from Riaan.
For some other reason, I cannot hear. I cannot hear you at all. I can see you talking, but I cannot hear you at all.
I will type it for you.
There we go.
Anyone has any question?
Questions which are, sorry, Lokesh, if I would intervene there. The questions that comes in from here, we cannot answer specific questions because it's related to individual families, but general questions we can direct it to Riaan. If you need further questions in relation to your particular case, your particular family dynamics, you could reach out to me, Sujit, or it's gentleman Sabu Varghese here. Two of us can guide you into what needs to be done. Riaan is our partner here at SV Wealth, who handles the Solus Trust bit, which is the estate planning bit. So we are a team that will work together. Any specific question or in general questions, please feel free.
Yes, there is a one question. What if a will is already there, but one of the witnesses later becomes a family member? And is the will still valid? I know Riaan cannot hear me.
No, I can now. So the sound's been sorted out, so I can hear you now. Yes, so it is at date of death, at date of drafting the will, that beneficiary cannot then be a witness to the will, so that should be fine. But I would recommend, in order to avoid potential issues, to potentially relook at that at a later stage in order to update the will accordingly.
Yes, hello, I have a question.
Mm-hmm.
I'm noticed when there's a discussion or a slide on life insurance payments, it said that the life insurance payment would go to the estate. I always thought that the life insurance payment would go directly to the beneficiaries. Is that correct?
Yes. Yeah, so you can decide who you want to designate as beneficiary on the life insurance. So you can have direct beneficiaries that it gets paid out to, or it can go to the estate. So in cases where it might be beneficial for it to be paid to the estate is if you, for instance, have set up a testamentary trust for a disabled child in terms of your will, and there's life insurance that will then be paid out to that beneficiary. It would then be beneficial to then rather have the estate as the beneficiary. It will then flow through the estate to that testamentary trust. So there's options to consider on how to best structure it. 90% of the time, most life insurance policies are structured in such a way that the beneficiary designates as individuals directly, because as I said as part of the presentation, that then avoids potential additional probate taxes and other implications.
Okay, all right, thank you.
So it's an advantage to go through the estate?
Oh, so my husband is asking, is it an advantage to go through the estate?
Again, as I said, only in specific situations where you would want it to flow through the will. So you've dictated in the will what should happen to those assets. Then it would be beneficial to consider the estate. But if you wanted to go directly to beneficiaries, that is the best tax as well as probate advice to have that done. But again, if it's a situation of you need to create liquidity in an estate, if let's say, for instance, you've got an outstanding mortgage of $1 million and you designate your friend as the beneficiary of a life insurance policy, that friend will receive the $1 million as a benefit through the insurance policy. It is not their responsibility to settle the mortgage. So the mortgage will still then be outstanding. So that's why looking at the bigger financial plan and making sure how that should effectively be addressed is what you need to have a look at.
So you actually have to designate your estate on your life insurance policy and not a person.
If you have not designated a person, default is that it goes to the estate.
I see. Okay. Did you have another question?
Yeah, are there advantages to having more than one executor?
Again, depending on asset and family composition, that will determine whether it is an advantage or a disadvantage. Because there's a lot of decision making and documents that will need to be signed. If there's co-executors acting in the capacity as your executors upon death, then both of them will need to sign documentation. I would recommend that in most situations, husband and wife are each other's primary executors. Because remember, as I went through the presentation, I spoke about joint assets and those kinds of things. That automatically then transfers across to the joint owner, husband or wife, and then have a backup to them, whether it be a trust company, a professional, or a family member. And what I have even other clients do is appoint an additional backup to them. But only in special circumstances, I would recommend more than one executor. Because if you've got a good structured will, it provides a blueprint of what should happen to the estate upon passing, and there's no need for a lot of involvement from different people as part of this.
Riaan, there are two questions on there. I'll bring that up. How often should the will be updated? And would holding companies which hold, say, a rental property can be a part of the primary will?
Yes, so how often it should be updated? I would recommend that at least once every 3 to 5 years, have a look at your will to see if it's still up to date. And then, as I mentioned as part of the presentation, any major life events, so divorce, death, remarriage, those are, and birth of new beneficiaries, those trigger an update of a will. And then, yes, a holding company, as I said, if you've got a holding company which holds a rental property, if you have only the one will, then that will go through the primary will. So I would recommend that if you are in a situation like that, is to have a primary and secondary will, because as I said, it's quicker to administer those assets because it does not need to go through probate, and you're going to be saving probate taxes as a result of that. And I see the next question is, will the executor share the fee in that case, the previous case that I spoke about? Yes. So if there's two executors and they act as the executor, an executor in Ontario, whether a professional or an amateur, can charge up to 5% executor's fees. I can tell you now, if you do consider, for instance, appointing Solus Trust as the executor, our fees are nowhere close to that. Again, to suggest earlier comment, if you have any questions, set up a meeting with them and we can set up some discussion.
Thank you, Ray. Lokesh, that's no questions out there. Anything that you would like to bring in?
Now we will go with the exit step, and I'll continue that for that matter. Thank you, guys. Thank you so much, Riaan, especially, and thank you, Sajid, for those incredible practical and insightful tips. Estate planning can be sensitive, as Riaan mentioned, and complex matter. But having this knowledge is a proactive step towards securing your family's financial future. Before we sign off, we would love to hear from you. Please let us know in chat or email us at info@akisa.ca if you found today's information helpful. We host these sessions for you, so please tell us. Would you like to see more webinars like this? Your feedback helps us shape our future programming. To ensure you do not miss out any of our upcoming workshop, please subscribe to ACISA's newsletter and follow us on our social media accounts. Thank you once again to our partners at the Indian Heritage Society and our founders, Canada's New Horizons Seniors Grant, and the Ontario Senior Community Grant Program for making this happen. I'm Lokesh Kajani, signing off. Stay healthy, stay informed, and have a wonderful rest of your weekend. Thank you, guys. Thanks a lot. Bye.
Thank you.
Thank you.
Thank you. Bye-bye.